بسم الله والصلاة والسلام على رسول الله. السادة الحضور، أرحب بكم في ندوة علمية جديدة من الندوات التي تعقدها أكاديمية نسيج عبر الإنترنت، والتي حرصنا على جعلها تنظم في هذا التوقيت المسائي مواكبة لروح شهر رمضان المبارك ومراعاة للطقوس الروحانية المرتبطة به من صلاة التراويح وقراءة واستهلالا واستلهاما لأجواء هذا الشهر الكريم. نجد الحق سبحانه وتعالى يقول في محكم التنزيل في سورة النساء الآية 58: بسم الله الرحمن الرحيم: إن الله يأمركم أن تؤدوا الأمانات إلى أهلها وإذا حكمتم بين الناس أن تحكموا بالعدل. والليلة سنتحدث عن نوع خاص من الأمانات أو الحقوق، هي حقوق التأليف والنشر، والتي هي ببساطة تلك الحقوق القانونية الحصرية التي تمنحها الدولة للمؤلفين والمبدعين بمختلف فئاتهم لحماية أعمالهم والمصالح المرتبطة بها، سواء فيما يتعلق بالتأليف أو الإنتاج أو النشر أو البيع أو التوزيع أو الاستنساخ أو الاقتباس أو إعادة الإنتاج والنشر أو العرض في أشكال مادية أخرى غير الشكل الأصلي أو في نفس الشكل، وذلك خلال مدة زمنية محددة تتفاوت من دولة إلى أخرى وحسب طبيعة العمل الإبداعي، مع مراعاة حقوق وضوابط أخرى مثل حقوق الملكية الفكرية intellectual property والاستخدام العادل fair use والبيع الأولي first sale وغيرها من الضوابط. في هذه الندوة سنناقش قضايا حيوية حول حقوق النشر والتأليف المعاصرة، ونمس بالأساس في هذه الحقوق كل ما يرتبط بها، خاصة تلك التي تتولى المكتبات الأكاديمية والبحثية ومختلف المكتبات تقديم خدماتها في إطار الضوابط التي تحكمها هذه الحقوق وكيفية حمايتها، وخاصة إذا كنا نتكلم في عصرنا الحالي الذي يشهد توجها كبيرا للتحول الرقمي، بالتالي تكون هناك فرصة لعرض تأثيرات تقنيات الثورة الصناعية الرابعة وزخم التقنيات الناشئة وتأثيرها على حقوق التأليف والنشر، كما سيتم التعرض للسرقات العلمية والانتحال الأكاديمي وكيف يتم تجنبه ومعالجته ومواجهته في نفس الوقت، مرورا بمشاركة الأوعية المكتبية المحمية بحقوق النشر والملكية الفكرية مع المستفيدين من خلال الإعارة على مختلف المستويات. وبانتهاء سوف نتناول الجوانب الخاصة بتأثير تقنيات الذكاء الاصطناعي على حقوق التأليف والنشر. وكان من الطبيعي أن نستضيف للحديث حول هذا الموضوع خبيرة متخصصة فيه، كما عودناكم في الندوات العلمية التي تنظمها أكاديمية نسيج منذ إطلاقها كمبادرة غير ربحية منذ أكثر من 8 سنوات، أننا نستضيف خيرة الخبراء والمتخصصين في المجال الذي تدور حوله الندوة. لذا فقد دعونا للحديث حول هذا الموضوع البروفيسورة سارة بنسون، أستاذ المشارك واختصاصية حقوق النشر والتأليف في مكتبة جامعة إلينوي بالولايات المتحدة الأمريكية، والتي تتمتع بخبرة طويلة في قانون المكتبات وقانون حقوق النشر والتأليف. كذلك قامت بتأليف وتحرير العديد من الكتب والبحوث والمقالات حول إدارة المكتبات وحقوق النشر والتأليف، وهي مؤلفة الكتاب الأعلى مبيعاً بيست سيلينج الذي يحمل عنوان Compact Copyright Quick Answer to Common Questions، الصادر عن جمعية المكتبات الأمريكية في العام قبل الماضي. Professor Sara, this was a very brief introduction to the topic and to you, and I would like to invite you to start your presentation, and we can postpone the question at the end of your presentation. So the virtual stage is yours to start your presentation. أرجو منكم الأسئلة تكون كما اعتدنا في صندوق الأسئلة والاستفسارات ليتم الإجابة عنها بمشيئة الرحمن بعد انتهاء الدكتورة سارة من العرض التقديمي. Please, Professor Sara, the virtual stage is yours.
Thank you. Thank you for that kind introduction. And today we are going to talk about world copyright issues in academic and research libraries in the digital era. And I know you have many questions. I'm going to be happy to get to them. We'll have plenty of time at the end. And I wanted to give you a brief overview of what I intend to cover today. So first, we're going.
One small comment, sorry, Sarah. For the people who likes to hear the presentation of the webinar in Arabic, they can click on the global icon down there, and they can move to the Arabic channel. We have an instant translation simultaneously with this one. Sorry, Sarah, you can go ahead.
Yes, thank you. And thank you for noting that it is being translated, and I'm going to do my best to speak slowly enough so that the translator can
Perfect.
translate as I go. So again, thank you, and thank you for being here, everyone. This is the brief outline of what I intend to cover. Like I said, there will be plenty of time for questions at the end. So please feel free to put those questions in the Q&A spot. I see some of you have already started to do that. I welcome you to add your questions there. So we're going to begin with copyright basics, talking about some of the very basic things about copyright, how copyright is formed, how you protect a copyright, and those things. And we will also cover the difference between copyright and plagiarism. That seems to be a topic that is of interest to folks, especially in academic libraries. We will also then talk about some world copyright issues. So as you are probably aware, there was a treaty that was enacted on the world stage through the World Intellectual Property Organization called the Marrakesh Treaty. So I will describe that treaty and also which countries have joined the treaty. And then I'm going to talk about some ongoing issues being addressed at the global level. There was a preservation toolkit just provided at the most recent meeting I attended at the World Intellectual Property Organization. So I'm going to talk about that and hopefully raise some awareness about the toolkit. Finally, I'm going to address copyright and artificial intelligence. I know that this is a big issue that everyone is facing collectively and our courts are struggling with. And so I will talk a little bit about that and then open up the floor for some questions. So let me move to the copyright basics. So as you know, copyright is one type of intellectual property. Intellectual property deals with things that are not necessarily physical property, but deal with the creativity and the output from our minds, right, from knowledge. And there are multiple kinds of intellectual property. There are specifically 3 types. One is copyright, another one is trademark, and the third branch of intellectual property is patent. So I talk and I specialize in copyright because it is the type of intellectual property most relevant to librarians. Why is that? Because the materials that we as librarians and libraries collect include books, videos, music, and also sometimes creative arts. But a lot of times what we are collecting is the written word, either in print or digitally through ebooks or databases of journals. And obviously, and most relevant, those works are protected by copyright. Therefore, we as librarians and in libraries need to know a little bit about copyright because we're going to have to engage with copyright in order to provide access to materials to our public. And so I teach courses here at the university, and when I talk to new librarians, I encourage them to learn as much as they can about copyright law, because the more you know about it, the more you can engage with the law to provide the most access to your patrons as possible. And I think most of us share that goal as librarians, that we want to provide access to our patrons, and in the case of my university, to the public. So what we are not going to talk about as much today is patent law. Patent protects inventions, right? So if you have a new drug that you create, that might be protected by patent. It doesn't mean that we don't deal with patents at the university. Often we actually do. Or that libraries don't collect patents, because many do. But generally speaking, the thing that we deal with more often as libraries and librarians is copyright. And the third branch of intellectual property, trademark, is mostly about businesses protecting their brand. Again, not to say that libraries don't engage with trademark. Sometimes they do. Sometimes we want to create a space in our library and give it a name. And that might be a name that another business is using. So we might have to think about trademark, but it's not something that we think about on the daily basis like we do with copyright. So today I'm going to focus on copyright, not necessarily patent and trademark. Okay, so what is the basic rule for how you get a copyright? It is very frequently misunderstood. People often think that you have to register a work with a specific office. In the United States, it's the Copyright Office, in order to have a copyright. But that actually is incorrect. Copyright is automatic, and what you need is a minimally creative work, and then you need to fix it in a tangible medium of expression. What does that mean? A minimally creative work is a work in which you have made some creative choices. So you have decided what words to put on the page. You have taken a photograph from a specific angle in a specific lighting. And then once you write it down, you take the photo, you paint something, then as soon as you put it in that tangible medium, either you clicked record, you typed it into the computer, you wrote it down, then you automatically have a copyright. So you do not need to register the work. You do not need to put a copyright notice on the work. Those things are helpful because a lot of people have misconceptions about copyright. They might think that everything on the internet is copyright free because it was distributed widely. But really, most things on the internet actually have copyright on them, and you don't have to actually put a copyright notice on a work in order to have a copyright. So copyright is most relevant. Oh, I think I already covered this. Hang on. I'm going to go forward. Oop. Okay. There we go. So this is kind of my general map of how you obtain a copyright. Originality plus fixation equals copyright. It means that when I talk about the minimally creative work, or when you've made creative choices, That is what we call originality or an original work. It is not a very high bar. So it doesn't have to be novel or new. It just has to have some minimal creativity. It's very easy to meet that requirement. And then the second requirement is that it has been fixed in a tangible medium of expression. In other words, written down or recorded in some way. It does not have to be something where you have saved it for a long period of time. It just has to have been written down. So even something you type into your computer, that is something that has been fixed. Now, then, like I said, you automatically have a copyright from that fixation. And if you just have an idea, let's say I think about a poem. I have a wonderful poem in my head. It's a beautiful poem. But if I don't write it down, I can't own a copyright on that poem. Another interesting example is that a complete defense to copyright infringement is that you came up with the idea on your own. So for instance, if I come up with an idea for a poem and I write it down here in Illinois, and Dr. Abdallah comes up with the exact same poem in his head at the exact same time, and he writes it down, neither one of us is infringing because we both came up with the independent creation of that poem. And again, that just shows you that if I go to register my work at the Copyright Office, if I do want to register it, remember I said it's not necessary, but here in the United States, I can't sue anyone for infringing my work until I have registered it. They are not going to check to see if I was the first one to come up with that poem, because that is not a requirement, right? That might be a requirement for patents. It's called something being novel or new, but for copyright, it's not required. So copyright is pretty easy to get. It's a very common thing, and it happens automatically. I use the example when I'm teaching. I say to my students that they are all writing papers for class, and I ask them if they have copyrights in their papers, and they look puzzled and they say no, they don't think they own a copyright. But in actuality, in reality, they do, because as soon as they wrote down their paper, it was minimally creative, they wrote it down or fixed it, then the copyright is automatic. And again, their confusion comes from thinking that they need to do something or register the work to have a copyright. But it is not a requirement. Okay, so the Berne Convention on Copyrights is something that most countries in the world have joined. So when the countries join this, it tells us some minimal things about their copyright laws, the requirements that they have to have in their copyright laws. So some of the things that are common in Berne Convention countries is that we have no copyright formalities for copyright formation. What does that mean? It means that we cannot require someone to put a copyright notice on the work in order to have copyright protection. It means we cannot require them to register the work with a copyright office in order to have copyright protection. So those are some of the things that I know of Berne countries, such as the United States, that is common across the world because that is a Berne Convention requirement of a treaty. Some other requirements is that we must have some protection for moral rights. This is very, very limited in the United States. We don't have much protection. We have it for visual artists in a small, limited instances, but we have to have some sort of protection there. We have to have exceptions that comply with the so-called three-part test. There's a three-part test that our exceptions must fulfill. We have to have a minimum copyright length. So the minimum copyright length under the Berne Convention is life of the author plus 50 years after they die. So copyright law lasts a very long time. It is meant to protect not only the author, but their heirs or their the people who inherit from them, such as their children and their grandchildren. We also have to have what's called national treatment. So we have to treat foreigners like citizens if they come to our country to sue for infringement. So those are some of the things that the Berne Convention requires. On this map, you can see when different countries agreed to the Berne Convention. The United States of America actually agreed quite late in 1989. Lebanon, for instance, agreed in 1947. That's much earlier. One of the earliest countries to agree was Tunisia. But actually, the United States, in my country, we did not want to join the Berne Convention because we had formalities, we had requirements that you had to have a copyright notice on the work to have protection. We had requirements that you had to renew the work with the Copyright Office to have the full term of protection. And even today, we have very limited moral rights. So we didn't really want to agree to that. But I will tell you, some of our rules in the United States differ a little bit. So I told you that the minimum requirement is life plus 50 for the copyright author today under the Berne Convention. In the United States, we actually protect authors longer. So we give them life plus 70 years automatically here in the United States. The longest copyright law that I'm aware of is in Mexico, where it's life of the author plus 100 years, which is very, very long. And I do know that Canada just changed their law to be the same as the US. So they used to have life plus 50, and they just added an extra 20 years, and now they're life plus 70. I think they thought our law was better. I don't know. I mean, if you think about the rationale of trying to protect your children and your grandchildren, 70 years after I die is a pretty long time. So I'm not sure why it has to keep going longer and longer. And 50 years after you die is a pretty long time too. But these laws are getting longer, at least in Canada. Okay, so this is the law in the United States. Like I said, that copyright is automatic once the minimally creative work is fixed or written down, recorded, and your copyrights lasts life of the author plus 70 years. But if you're in a Berne Convention country, chances are your law is life plus 50 because that is the minimum required. And that is the majority of countries in the world, actually. The United States is not in the majority. We have a longer copyright. So what does copyright law protect? It protects all of these things. It protects software. So software and coding of computers is considered a language and is protected as such under copyright. It protects writing, books, journals, those things that we collect at libraries. It protects artistic works and sculptures, architectural plans, musical scores and compositions and recordings. So some of the things that copyright law does not protect include facts. So you cannot own, a date or something of that sort that is a fact. In the United States, you could have a thin layer, a little bit of copyright for the arrangement of facts, but not the facts itself. We cannot protect ideas in copyright. First of all, if you haven't written down the idea, we definitely can't protect it. And second of all, if it's too broad of an idea. So for instance, a genre, like the genre of like romance novels, right? That is too broad. I can't say that I own all romance novels, right? That's just too broad for me to own. And then we don't have copyright over short phrases and titles. That might be trademark. So if there's a title to a book, you're not going to be able to copyright that title. That might be trademark, but you cannot copyright it. And then if there's a method of operation or an invention, you cannot copyright that, but you might be able to patent it. So when you have a copyright, like I said, it's automatic. You automatically have the exclusive bundle of rights. So this is what we refer to as the author's bundle of rights. So that you have the right to reproduce or make copies of the work, to distribute or sell or put the work out on the internet or out in public, make copies of it for public. You can create derivatives of the work. So if you do a full translation of a work, that is considered a derivative work. You have the right to publicly perform the work and the right to publicly display the work. So you have all of these rights automatically as the author, and then you can license any of these rights to others. License is just a fancy way of saying contract, and so there are a lot of contracts involved with copyright. As we know, at libraries, we enter into licensing or contracts all the time, specifically for ebooks, right? We have, or databases, journal databases. And when we do that, we can lose any rights that we have under copyright. We might have exceptions to copyright that are specific for libraries or for archives written into our laws. If we do not reserve those things in the contract specifically, then we are waiving them, we are giving them up. So because the contract controls, copyright law can be overruled by contract. So it's very important to read those contracts or those licenses very carefully and to reserve the rights that you need and the rights that you're given as a library or an archive. Okay, so what is the difference between copyright and plagiarism? Copyright is a legal issue and it requires permission to use or reproduce or distribute an item. And so if you violate copyright, you can be sued for that violation. However, plagiarism is an academic standard. So plagiarism requires proper attribution or citing or quoting of an item, whatever thing you are using. If you violate plagiarism rules, you won't be sued in court, but you might get a failing grade. You might get thrown out of school. You won't get your degree. And so while they are similar, and sometimes something that might be a copyright violation would also be plagiarism or vice versa, the outcome is very different. And sometimes there are cases where something would not violate copyright, but would be considered plagiarism. So they are not exactly the same in terms of their rules and in terms of how the rules apply. And the outcomes can be very different, right? One, you would fail a class. The other one, you would get sued and maybe have to pay money, right? If you're held liable. So they are different. They tend to happen in similar ways, right? By copying something without permission. But again, the outcome is very different. Okay, so how do you avoid plagiarism? Well, every time you paraphrase something from another author, you cite the work. And every time you quote directly, you use direct words from another source. You use quotation marks around those words to indicate the quotation, and you cite the work. If you do those things, then you're not going to be committing plagiarism. Now, let's say I copy an entire book cover to cover and I put quotation marks around it and I cite it and I say, well, I'm not committing plagiarism because I quoted the whole book and I cited it. And while that may be true, you're still violating copyright because you didn't have permission to copy that entire book. So again, sometimes plagiarism and copyright align and it's the same thing, and sometimes they're different. So it's important to kind of think through those as different issues. Okay. So there are some library services that overlap quite a lot with copyright, and where they overlap is in these three areas. So I'm going to discuss these three areas. The first is first sale or copyright exhaustion. The second one is when we have copyright exceptions and limitations. And the third one is copyright licensing, which I've already mentioned a little bit. Okay, so what is first sale? We call it first sale in the United States. In most places around the world, I've heard it referred to as copyright exhaustion. So if I'm referring to first sale and it makes more sense for you to think in terms of exhaustion, that's fine too. So first sale allows anyone to lend or sell physical books. Why? So this is how most library lending in the United States takes place, is not under any copyright exception at all, but under our right of first sale. So the idea is that the publisher made money from the first sale, from the book being sold first, and after that, they don't get to control how the book is used. So for instance, in the United States, we have what's called little free libraries. I don't know if you have these in your country, but we have people who set up a little shelf with books in their front yard, and people can come and borrow a book, or they can leave a book. They can do that because the publisher sold the book, and now the person who owns it can do whatever they'd like. They can lend it. I can lend my book to my friend. I can sell it at a used book sale, at a garage sale, at the library can sell books, right? We have sales in our public library basements. So that's how we do a lot of lending, right? Is because the library purchases a physical book and then we lend it to our patrons, and hopefully they turn it back in, and hopefully it's in good shape, right? And then we lend it out again. And we in the United States do not have to give any money to the publisher for this, or the author, right? The author got paid as well when we first purchased it, usually in the form of royalties. And so we lend it and lend it and lend it, and then eventually we get our preservation team to try to preserve the book as long as we can, right? So this slide kind of describes what I just said, that the United States operates under this right of first sale. There was a very famous Supreme Court case all about the first sale right, where a student who was from Thailand studying in the United States went to his home country in Thailand. He purchased textbooks that were written in English from Thailand. The books were being sold there much cheaper because the market is that can't afford the prices that they sell in the United States. So he bought them there. And then he sold them in the United States and made a huge profit. He made over $1 million. And the publisher said, wait a minute, we want some of that money. So they sued that student. It went all the way to the United States Supreme Court. And the Supreme Court said, no, publisher, you don't get any of that money because of first sale. So they said, you sold the book. Yes, you sold them cheaper in Thailand, but that was the decision you made. This student was smart, went to Thailand, brought all these books, and then made this money. And that's the money the student gets to keep. So it's a pretty powerful right in the United States. So what does this look like in some of the Middle East? Is there a right of first sale in the Middle East? So in these first countries, Saudi Arabia and the United Arab Emirates, there is no right to first sale that I could find. But in Egypt, there is a right of first sale in Article 147.3. So potentially in Egypt, I suppose they could be charging for the resale, basically. But with no right of first sale, then all library lending is permitted. One thing that is being discussed on the international scene right now is public lending rights. So some countries, such as Canada and Europe, charge a fee for library lending, and it's paid to a collective for distribution to authors or for some other purpose. So when libraries are lending, they are having to keep track of how much they're spending or how much they're lending a particular book, and then pay per each lend to a collection society, a collective society. In my opinion, this is not a good thing for libraries. I do not think that this is good. I much prefer what we have in the United States, where we don't have to do this. I think you should keep it on in your thoughts, though, because there is at the World Intellectual Property Organization a study going on all about these public lending rights. And again, they are not uncommon. They do take place all throughout Europe and in Canada. And the publishing organizations are very keen, very much want them in other parts of the world. They are pushing for them, say, in Africa. And the reality is that this could be a real problem for libraries who can't afford to pay all these fees. Where are the fees coming from, right? So it could be a problem. I understand what the desire is to pay back all these authors, right? But it can be a real problem. So I would definitely keep on top of that. Stay aware of those conversations that are happening. Okay. In the United States, we also have an exception to copyright for face-to-face teaching. So when we are in a physical classroom in front of students, We have an exception that allows us to display or perform any work. It's a very broad exception. It's really useful. So we can show a full-length movie in a classroom. We can show contemporary art in a classroom, right? Because when they were passing the Copyright Act in the United States, they understood that if we can't do these things and we have to ask for permission every time, we're not going to be able to do our jobs as educators. Note, though, that this face-to-face teaching exception in the United States does not allow for reproduction. So it's not saying, oh, you're in a physical classroom, you can copy an entire textbook and hand it out to your students. No, it's about the display or the performance. So I can show something to my class and my students can show their work, say in a PowerPoint, but it doesn't apply to copies. We also have exceptions for preservation and interlibrary loan. In our country, in the United States, the preservation rules are very broad. They're very good. Our interlibrary loan rules are very good. Again, this varies from country to country. I know in South America in particular, interlibrary loan is very limited. We also have access to works for the visually impaired, which is really important. We can copy and share entire works in a format that is screen reader friendly for someone who is visually impaired so that they can listen to the book. And we can do that across borders. We can share across different countries as well, which is also a good thing. So recent work that has been happening at the international level, and at the international level, they are really concerned about things that impact many countries across borders. That's where treaties really can help. So the treaty for Marrakesh was for access to works for the visually impaired, specifically across borders. So not just within one country, but across many countries. So the Marrakesh Treaty allows member countries to enact legislation allowing for the copying of materials for visually impaired patrons, as well as otherwise print disabled, including physical disabilities that might impair you holding a book, for instance. Mostly it's for the visually impaired, without violating copyright. And this allows for also cross-border sharing as well. So in the United States, we actually already had a law allowing us to make access to materials from libraries for visually impaired patrons. So a patron could say, I can't read this book, I need a screen reader friendly version, and then we could copy the book and make it available to the patron for screen reading. We had that already, but when we joined the Marrakesh Treaty, when we enacted that law, it not only allowed us to do it within our country, but to also share it with other countries that have also signed this treaty and enacted laws pursuant to the treaty. And that was a big deal. So who signed this Marrakesh Treaty? So we in the United States signed it in 2013, but it did not have the full force of law until 2019. So that was quite a while. It took some time to enact our legislation. Many of the Middle Eastern countries also have signed it, and it's in force as of this 2016 or 2019. So that's good. It looks like Egypt has not signed it yet. So this is something that you might want to encourage if you have Egyptian colleagues to talk to their legislators about. But what this allows is that if we in the United States have a book that you don't have in your collection, or let's say you have a patron who wants a book in English, right, is trying to have a screen reader in English. And we have it. Our Library of Congress is working to provide those books. And so this is a good thing. And these countries can trade those screen reader enabled books with the United States but vice versa. What if we have a patron in the United States who needs a book in Arabic and they need it for a screen reader? We might be able to get that from your country. So these are good things that have happened. And this happened at the World Intellectual Property Organization. So some things have been happening at the world scene there. So this is really, really, really recent stuff. So I just got back from Geneva. I attended my first meeting of the Standing Committee on Copyrights and Related Rights at the World Intellectual Property Organization, not just a few weeks ago. So it was very recent. And they just released this preservation toolkit. So what is it? It is not a binding agreement. It is not a treaty. It is nothing that is signed by countries, but it is a guidance document, and it's a useful document, especially for lawmakers. And in this document, it's telling libraries, archives, and museums how to enact laws to allow for library preservation. This is so important, right? Especially today with global warming, with climate change, also with wars happening, right? We see a lot of materials in the Ukraine getting destroyed. We also had a fire that happened in South Africa where they lost a lot of their library collections. So we really need to document our history and our collections and make those copies for preservation, right? A lot of times we are maybe too scared to make those copies because it might violate copyright. And that is why we need an exception to copyright to allow us for preservation. Otherwise, also, another issue is that cross-border preservation issue, right? I think my next slide gets to that. So I think I already said this. Yeah, why we need to preserve our cultural heritage works. I think everyone understands that need, right? That we don't want to lose them due to emergencies, fires, natural disasters, all of those things. So the other thing, like I said, is it's not only within our own country, but if we share across borders, then we are even more likely to save those important documents, right? Because if something happens in the United States or something happens in Africa, like South Africa, if they had shared across borders, across to their neighboring countries, and the fire happened in one place, likely the other place would have that copy still. So, and also some collections don't exist in one place. Sometimes we have part of a collection in the United States and part of a collection in France. And so we need to share those copies so that we have a complete collection that we can preserve. So this slide is talking about our exception to copyright in the United States. That is a very good, very broad exception. So in the United States, our preservation for libraries and archives happens under Section 108 of the Copyright Act. And it allows us to engage in interlibrary loan as long as we're not, trying to avoid subscription prices. And we don't share entire works. We can't copy an entire book unless it's not otherwise commercially available. So there are some checks and balances there. But for preservation, especially for unpublished works, it's just a broad right. It says that we can automatically make that copy. Why is it so broad? Well, if my library has a letter written by George Washington or something like that's probably a bad example because it's probably out of copyright. But think of someone a Barack Obama or someone like that, that's recent, it's still in copyright. But if I have the only letter that he wrote in my collection and I cannot make that copy, if something happens to that letter, someone spills water on it, something damages it, it's just gone. So that's why we want to make that broad right to preserve unpublished works. So it's automatic. For published works, it's a little trickier if they're in copyright. They only allow us to make the preservation copy if they're deteriorating or if the copy is lost. So if something has come to our preservation department and it is falling apart, then it does allow us, as long as we can't replace the thing by buying a brand new one. If it's an older work still in copyright, we can make that preservation copy. So it's pretty broad. So I wanted to give an example from Saudi Arabian law, and I'm not an expert on Saudi Arabian law, and so, I don't want to claim that I know your law in and out as much as you do. But from what I have found looking at Kenneth Cruz's summary, he did a study in 2017 of all the library exceptions around the world. And in there, I found that in Saudi Arabia, if you make a copy or two for public libraries or for a non-commercial documentation center, you can do so if you're not going to make a profit off of it, right? It's not commercial. You are copying restricted to the requirements of the activities. So if it's preservation, it has to be for that reason. You cannot impair the material benefit of the work, so you can't replace the market value. But the next one, I believe, is the hardest one to meet, if the work is out of print or is lost or damaged, okay? So this seems like you have to meet all of these requirements, and I don't really see an exception for unpublished works. I'm kind of assuming that most people would feel that they need to make a copy for preservation of an unpublished work. But if all of these things are required and nothing is mentioned about unpublished works, it seems a bit limiting, and I would recommend looking at the toolkit language. The toolkit language is meant to guide lawmakers. So it can help to try to create some new laws that would be maybe a little more beneficial to libraries. Okay, the next example that I have is from Egypt. So what I found in that document by Kenneth Cruz is that in Egypt, intermediaries of documentation and archiving centers and bookshops not aimed at making a profit can make preservation copies of works for preservation purposes in any form. That's pretty good. That's basically saying, if you're not trying to make a profit, you can make a preservation copy in digital format, whatever format you need. They say you can only make a copy if it is impossible to obtain a substitute copy under reasonable conditions. Well, if something's unpublished and it's the only letter from, say, Barack Obama or whoever that exists in the world, of course you can't find a substitute copy. So that seems like for unpublished works, it's pretty automatic. You can make the copy. So I think this language sounds pretty okay. It sounds like in Egypt, you can do it. So that's good. We need, and one thing that we're trying to do with this preservation toolkit, especially at the World Intellectual Property Organization, is point out that the more our laws are different across different borders, the harder it is going to be to share those preservation copies, right? So the law here, for instance, between the US, Egypt, and Saudi Arabia is very different. And that means it's going to be hard for me as an archivist or a librarian to decide if I can share a copy in Egypt, right, across borders. And so that's why having a treaty would be a good thing. Unfortunately, it seems like some delegates from different countries are really not interested in a treaty at this time, but it is something that has been on the agenda for a very long time. And at the very least, we can use the toolkit to kind of work for change in our own countries. Okay, so here's another example. In the United Arab Emirates, record houses, archives, libraries, or documentation centers can copy for preservation when done for non-commercial purposes. Sounds good so far, but then it says only a single copy of the work can be made. And copying is only allowed where a substitute copy cannot be obtained under reasonable conditions and the original work is acknowledged. So in the United States, our Section 108 law says we can make up to 3 copies of the work. And that is also quite limiting. However, what we have done in the United States is we extend that through fair use, because we also have rights to fair use. And Section 108 specifically says that our rights are not limited and can extend into fair use. And so we often have more than 3 copies. If you think about it, if you make a digital copy of a work, you automatically have multiple copies, right? Because that digital copy is going to archive and it's going to go different. You might email it to someone and you're going to put it in, you know, a storage cloud, right? You're going to have more than 1 copy. And so I recommend looking at the toolkit. I think that this is a little bit limiting with the single copy. Otherwise, that's pretty good, but that single copy sounds quite limiting. Okay. So again, I was pointing out that the reason that we have the toolkit is because we've been discussing these cross-border preservation issues. And, you know, we really struggle to have collections where we can share across the different countries. And this is an issue that really faces all of humanity, right? We all want to preserve history. We all want to preserve culture. But our laws may be getting in the way. They may be preventing us from doing that, and that's a problem. So this is something that is ongoing work at the World Intellectual Property Organization. We haven't solved all of the issues, but the preservation toolkit, I think, is a real step in the right direction. Just a side note, the next thing that they're working on under this issue at the World Intellectual Property Organization is a toolkit not only about preservation, but how do we access those preservation copies, right? So it's great that we can preserve it, but then can a researcher look at it? Can the library share it with any patrons? Can we share it with other libraries, right? All of those access issues that come along with it. That's the next toolkit that they will be working on. So keep your eyes on that space. It's going to be ongoing discussions. The next meeting of that committee is in November of next fall. So I will be there in Geneva again in November. And I'm hopeful that we'll have the next toolkit by then. But for now, if you search for the preservation toolkit on the World Intellectual Property Organization, you should be able to find it. And the great thing about the World Intellectual Property Organization is that they do translate their documents. And so you should be able to find a copy of the toolkit in your own language, not just English. So hopefully it's more useful because of that. Okay, so thank you for bearing with me on some of the things that I wanted to talk about. I know what many of you are really excited about and most of us are struggling with is the proliferation of artificial intelligence-based services on the internet. So, you know, we have ChatGPT, we have OpenArt, Midjourney, and all of these things involve copies, right? And also creating new things. So how does copyright deal with this stuff? How do we handle this as librarians and as copyright people who engage with copyright? So some of the issues that arise in AI in terms of copyright is, who is the author, right? So the person who created Midjourney wrote the code for it, right? But then that program created its own thing, right? With a prompt from a user, someone goes in and says, show me pictures of cats as aliens, and it will, come up with brand new things, brand new images. So who is the copyright owner? And the United States Copyright Office says, if you do not have a human author, you cannot have a copyright. So some of the use cases, they seem silly, but there was a case where an orangutan, a monkey, took a photo. I don't know if you heard about that, the monkey selfie. So a monkey was given the clicker, right? And took a photo of himself. And then the person who gave the monkey the clicker said, well, I own the copyright on that because I gave him the clicker and I set it all up. And the Copyright Office said, no, the monkey took that selfie and the monkey is not a human. There's no copyright. Well, that's what they're saying essentially with AI, right? They're saying, okay, well, the computer created this thing. No human really did it. Therefore, there's no copyright. Okay, but is there still potentially some copyright infringement going on behind the scenes? Probably so. So where does that happen? Like, first of all, how did Midjourney, or how do these art or even, ChatGPT, how do they get the content that they're using to create the new output? They got it from the internet. And like I said earlier, most everything on the internet is copyright protected, right? And so they copied all of this stuff and put it into their database for then the AI to create new things. So that could be a copyright infringement right there, right? That copying. In the United States, we have, the limitation on the copyright owner called fair use. And many folks think that that initial copying might be justified under fair use. So even if it is, what about this new image that pops out, right? That comes out. So let's say I ask Midjourney to come up with cats as aliens. And one of the images looks exactly like another image on the internet, even so much so that I can see the watermark, right? The note, or even the copyright note, right? From the original author. It didn't get rid of that. And you can trace it back and say, this looks substantially similar to this other thing. This looks exactly like this other picture by this artist. And so if it is substantially similar, and if the artist can show that the work was copied, there's potentially some copyright infringement going on. In the United States, like I said, also contract can trump copyright. And if you're scraping or scouring the internet and taking all these photos, probably on all of those websites, there are terms of service. And a lot of websites say you're not allowed to copy this stuff by contract. So there may also be contractual issues here, right? A breach of contract issue. even if it's not a copyright issue. Maybe it's a breach of contract issue. All of these things are I say maybe because we don't know yet. We just don't know yet. All of this stuff is brand new, pretty new. And guess what? All of the experts are still trying to figure this out. So the U.S. Copyright Office, speaking of experts trying to figure this out, they are doing a study right now to try to determine how to handle copyright in AI. And here's the link. You can follow their studies and follow what guidance they give because it's a real issue and it's a developing issue. The World Intellectual Property Organization has also been talking about copyright in AI, and you can follow their discussion of it. But I don't think that we are going to come to any grand conclusions today because it's such a new issue, and I think the courts are still going to have to struggle with this for a little while, as well as the Copyright Office and giving guidance. So I think that this is going to be something that we're going to be talking about for a while. And I think if you follow these websites, hopefully you can stay on top of the issue because I can't tell you the exact answers today because everything is still developing. So that is the crux of my talk. That is what I came here to tell you about today. I'm really happy. I see a lot of Q&A there, so I'm hoping that we have a lot of questions, and I'm happy to answer them.
Yes, for sure. We have plenty of questions, so let's have a telegraphic answer because we need to fulfill the need and also to respond to the inquiries we have. So I invite also more people to give our question. Before that, I would like to thank you again, Professor Sara, for this interesting and informative, very informative presentation, which gave us, I think, a crystal clear understanding of the copyright and the related issues, especially within the digital era we are living in right now. Also, the outstanding comparison journey that you're talking us between different countries and how the copyright laws not look like different, but at least have a very distinguished feature in it, if you agree with me. So thank you for this very informative presentation. And let's go very quickly to the question we received. And let's start with the first one, which comes from Ms. Khadija, the library service manager from Mohammed bin Rashid Libraries. I'm so happy that we have very unique attendees here. And she said that in United Arab Emirates, we are paperless government. So we do care of this issue in printing or copying any book, but allowed for digital scanning for public. They are free to send it to their email with our watermark logo. The question is, are we have the right to restrict readers and researchers from not copying this? Please, Sarah. Yes. Thank you, Ms. Khadija.
So if you're sending them for their personal use, a copy of something that is in copyright, then they should be using it for that purpose, right? So we often in the United States will allow users to have a copy of something. For instance, through interlibrary loan, we might give them a digital copy as well of, let's say, one article from a journal, or one chapter. We'll make a copy and send it to them by email of a chapter from a book. But that does not then allow them to say, put that same chapter on the internet or, further share it. Because if it's still copyright protected, if they need to make further use of something, they would need to ask the copyright owner for permission. And so in our instance, I get this question a lot from patrons. They'll say, Sara, can you give me permission to use this book or, in my dissertation or in my publication or this image from this book or something like that. And I tell them, I wish I could, but I'm not the copyright owner and our library is not the copyright owner, right? We collect many different types of works, but we don't own the copyright for them. Usually the publisher is the copyright holder. So if it's a physical book, it's usually the publisher of the book. If it's a journal, it's usually the publisher of the journal. The exception where we actually own the work is usually in our archives, where we may actually have a deed of gift from the owner, the copyright owner, transferring the copyright to our archive. So in that instance, we might actually be able to give permission. But that's a very limited example. The only other place where we can grant permission is where something's in the public domain because copyright has expired. But in that case, they actually don't need permission at all. And so in that case, I just tell them, we believe this work is in the public domain and, you don't need any permission. So those are the only two exceptions. Usually, if they want to make further use of the work, they would have to make their own, either get permission or they would have to make their own assertion of fair use in our instance.
Perfect, thank you. Also are happy that we have Dr. Tharwat Al-Alimi with us, and he has two questions. One, he started with it. It's related to the AI, and he asked how to protect intellectual works created by the artificial intelligence software in academic libraries. I think you mentioned it at the end of this one, so we would like just to give more elaboration, Sarah, about this, and then we will talk about the second question from Dr. Tharwat. Yes.
So he's asking if someone creates a work through AI, how do they protect it?
Yes.
And I think that the answer is we don't know because usually I think you might be able to own something in it. Let's say you use the chat GPT and GPT, and you create something, but then you go in and you substantially edit it. So once you have gone in there and substantially edited it, I think you've put your human touch on it enough. And if you have minimally creative output that you've put into that, I think you might be able to copyright that at that point. Although, if it's just the chat GPT that spit out something, I think then you're going to have an issue, likely.
Yeah, and I think if you allow me to elaborate more, the ChatGPT version 4 is now trying to handling, this competition that's now between this type of new technology. So Google and Microsoft and other companies trying to give more effort on this one. So I think there is some more effort has been done to protect the content and also to give what we can call it more resources about if this come from the chatbot GPT or it is something from a specific resource that we can cite it. So thank you for this one. The second question from Dr. Tharwat is about the reprography are widely used form of distribution of literary and digital content. Okay, therefore, the reprographic association becomes a key partner for authors and publishing companies because authors need to know who are copying their works. I can feel it, Dr. Tharwat, yes, in libraries. What do you think of the role of reprographic association nowadays with the use of the principle of fair use in the academic libraries? Please, sir.
Reprographic, are you talking about the people who help with the scanning? That type of?
I think he's talking about that the way that you can know who is just copying more from some work on this one. So let's make it in a way that what the academic libraries could help in this one just to at the same time serve the authors and publishers to protect their rights, and at the same time, not preventing the user from having the right to copy some of the works. Please, Sarah, yes.
Yeah, so I think that really depends on the laws of where you are, right? Copyright law is very territorial. Therefore, it matters where you are doing the copying. So, for instance, in the United States, we have a very broad right of fair use, and that allows quite a lot of copying to happen. And I know, the publishers may not like it. They very much sometimes don't like it. And in fact, they do sue. If you were been following the Internet Archive lawsuit, we recently just got a summary judgment in that case in favor of the publisher saying, hey, you're distributing our works, too widely, and that's illegal. So it depends on really whether it is a fair use or not, and that is a very case-by-case analysis. So a good example where the court said something was clearly a fair use is where the HathiTrust library, it's a digital library, made works available, but if they're in copyright, you can only see how many times a term came up on a specific page. So if I'm searching for some term, let's say heart disease, did it come up on page 95? Yes, 5 times on page 95. You can't see the work itself. And in that case, the court found it was a fair use. But in the Internet Archive case, they said, no, you're not just making, search terms available. What you're making available is an entire work, and someone can read the whole thing, and it might even be brand new. And they said, that's not a fair use. You cannot do that. And that was the recent ruling that just came out.
Thank you. Thank you, Sarah. I think related to that, we have from Maytha Darwish in BRL. She asking about how the users could do this copying activity, even they are not allowed to copy more than 10% of the work.
Yeah, so in the United States, there is what's called Circular 21 that was put forth by the Copyright Office, and it is trying to explain fair use under U.S. law, but it is pretty outdated. It was written around 1976, and it really hasn't been updated since then. And so it is fairly out of date. And courts have specifically said there is no 10% rule. And really under the U.S. copyright law, the fair use determination is a case-by-case determination. So it's not a specific amount. It just depends on the factors of fair use and whether something is for educational nonprofit purposes, and whether the use is limited to the amount needed and things like that. So again, if you think about the HathiTrust case that I mentioned, in that case, they copied entire works that were still in copyright, but just made the terms available when searched. So
yes,
the fair use is not based on a specific percentage, but it's more about what the use is for, and as long as the use is educational and fits the needs of the audience.
I'm totally agree with you, especially if we said that the 10% could be the core of the work. So if you're just focusing about maps or charts or something like that, so maybe 1 or 2 pages will be the core. So it's something need to be, as you said, case by case. Okay, we have a question here. It's about the difference between countries in how to protect their work. Okay, the question from Mr. Sani. Yes, he said that about how the country can protect the copyright for its authors outside the country's border, especially if this happened in another country that is not joining Berne Convention, or it is in a very rare language. I like this.
Yeah, that's a really good question. And I think it's a really difficult one, because really, if you haven't joined the Berne Convention, then other countries feel no obligation to follow your country's laws or respect them. And that's unfortunate. But I will tell you, most countries in the world have joined Berne. And I would say if that's the concern, to try to ask your government to join that convention, because I think that that's the key really to getting other countries to respect the law, right? Is that there's a reciprocal benefit there, right? That we will respect your law and you'll respect our law. And if you don't join the Berne Convention, then other countries don't really feel a need to do it because there's no threat like to them that they will be sued or anything like that. So I would say if you're not a member of Berne, that you should try your best to talk to your government and try to join the Berne Convention. It's a very important thing to do.
Okay, thank you. Another question, in your opinion, what is the perfect number of years that should be at risk to protect the creative works or the work that also and there is another question that related to it's in Arabic, that's why I collected with the other one. Okay, till when the protecting the copyright stay after the death of the author?
Until when? So if it were up to me, I would have copyright law be a lot shorter, because really what the whole goal of copyright is to incentivize the creation of works and to remunerate the author. So to me, if it followed the author's life, that would be enough, right? But
yeah, fair enough.
But I do think, I have no control over that, because in the United States, it's author plus 70, whether I like it or not. So
I can tell, yes. So range from 50 to something like 75, it's pure, it's fairly acceptable, right? 50 till 70 something, or maybe less than this.
So the general default under the Berne Convention is if you've signed onto the Berne Convention, your country must have a minimum of life of the author plus 50. And that is what the rule is in most of the world.
Okay. Okay, so we have another question here. Okay. As you know that copyright is a joint right for both author and publisher. How do you see the best relation should be included in the contract between both of them to protect the right of each one? So talk about the author and the contract between the author and the publisher.
Yeah, so I do a lot of talks with our authors here on campus. So we have a lot of faculty who write books and a lot of faculty who write journals. And I do encourage them to negotiate their rights with the publisher, because I think often what we do is we just sign the contract without even talking to the publisher to see if we can change any of the terms. But often if we do talk to them, they are willing to change some of the terms. So one of the things that I encourage faculty to think about, especially with journal publishing, is how they want to reuse their journal article. So if they want to use it to teach, if they want to use it for conferences, if they want to use it in future works, they might want to try to get an addendum or some sort of modification to the contract to allow them to do those things, because otherwise they have to ask permission every time they want to use their own work. And that can be really frustrating for authors. And so it's really good to think ahead about those things and get them written into the contract from the beginning. And that way it will save a lot of frustration later.
Okay. Thank you. Ali Amri is asking, today I am getting ready to present my first book, and I am obsessed with getting plagiarized. How do I avoid falling into the trap of preserving the rights of others while preserving my rights as well? And I am a great reader, and I am afraid that the idea that I wrote is fully preserved in my mind and written in my book as mine when it is not mine. Okay, so he's afraid about, the idea that you raised about the same idea could be in different mind at the same time. So he's trying to be precaution about to protecting this one. Can you elaborate here?
Yeah, so the same idea can be in somebody's head at the same time, but the way you protect it is if you have actually published a book and your publisher registers the copyright, then the reality is if they then do it, you can try to show that you did this first and that they stole it. Now, if they came up with the idea independently, that is a defense. I'm going to give you an example because it's best to think in examples. One of the common cases about this type of thing is music. So often what happens is a musician comes out with a new song. An older musician had a very similar song.
Yes.
And they say, you stole my song. And the new musician says, no, I didn't. And then they can't prove that they heard the song. But you know what they do? They say, well, were you listening to the radio in this year, in this location? Because my song was played almost every day on the radio. And then they say, oh, no, I did. I heard it, right? Because that's how you prove they copied it. And so that would be the similar thing you'd have to do is try to show they had access to your work and that that they used it.
Yes. Okay, I think it's need really to be caution on this one. Okay, this is a quick one. It's about the computer programming language and the systems. How the copyright applied on this one. Maybe he asked about the technique or the mechanism.
Yeah, so that's a really complicated question. And the reality is that computer programming languages are copyrightable, but remember that if something is functional, that's not copyrightable. So there's kind of a line. So copyright is all about creativity and originality and not about function, right? And so if something that you wrote in a computer program is all about functions, like, some key that makes something print or, some sort of language that is very functional, that's not going to be copyrightable. It's the creative new stuff that you come up with. So there was a very recent case at the Supreme Court all about Google was being sued for some language that they did. In that case, they actually found fair use, but they could have easily looked at function because the language that they stole was all functional language in programming. So that's the line you've got to think about is the creative output versus merely functional.
Perfect. Okay, thank you. We need you to give us more enlightenment on protecting the works that developed and presented in the digital world like Second Life and Metaverse.
Well,
and this is what we call it the $1 million question, I guess.
Yeah, exactly. I mean, I think that's like I don't know what the answer is because I don't think anybody does yet. I think we're still trying to figure all of this out. Maybe the next time I talk, the U.S. Copyright Office will have some more guidance and I can, build on that. But I think at the moment, yeah, you've hit on the $1 million question. I don't have all of the answers because everything's developing.
Yeah. If you allow me, I have an experience just writing an article about the application of Second Life in library science. This is what I think 2009. There is some rules within this virtual world. It looks like a code of ethics. So you can't, for example, copy the avatar dress from one to other side, and you don't have to say bad words within this one. You can take stones, just shape somehow some art items, artistic items. So if you did something like that, it looks like a plagiarism at the same time. So maybe you will get out of this world somehow. But as you said, that need more, I think, digging in deep to not control, but at least to organize how the thing is done. And I think in Metaverse, it's still they are still working on something like that. You have to protect the arts on this one. And this is, I think, leads us to the other question related to that. It's about the type of arts. I saw the question, it was here, yes. Okay, so this is, you know, that the non-fungible token arts, you know, that the NFT works that is already copyrighted for the digital work. So would you just again give us some of your reflection on this type of digital works that is protected and sell for one time for specific people?
Yeah, so just like any other work, as soon as it's created, the copyright applies. So even if they're creating it digitally, even if it's a non-fungible token, they did put if they put minimal creativity into it, then they automatically own the copyright. And then copyright laws apply just like they would apply to anything else.
Okay, okay. Thank you. There is a high level question. It's about the responsibility of protecting the works. Is it for the law or the community or the country? Or he said that, or maybe the UN can do something in this one.
I mean, I think that the responsibility of trying to balance copyright mostly falls on the government with the laws, right? But then we follow the laws, right? At least we should. And so I think, you know, one of the things that was pointed out on the preservation toolkit, Kenneth Cruz was one of the expert advisors on the panel, and he pointed out that copyright law is a balance, right? Not everything is about library exceptions and preservation. There's also a lot of protection for publishers and authors, and the law needs to be balanced. And then we need to follow the law. So we have to start with the law, right? And this is why the preservation toolkit is so helpful, because it can help us get those those good balances in our law, right? That allows for preservation. But yeah, and then we have to respect it. We have to not ignore the law, right? I mean, one of the things that I do is I try to tell people, you know, what is fair use, what may not be fair use. And I don't encourage people to violate the law, right? Because that is not a good thing to do. And you can get in trouble, and it's just not ethical. And so I think we have to have good laws in place, and then we all have to understand them, and we have to abide by them.
Yes. We're still receiving question about it, but I have to apologize for the recent question, because we try to stick to the time frame. The last two questions, one of them is about the future of the copyright as you see it, and the other one is about the penalty for breaking or violating the copyright. So you can start with, I think, the second one, and then make the future or expectation, the last one. Please, Sarah.
So I think that the penalty varies depending on your law. So in the United States, it can be a pretty high penalty if it's a federal violation, and you violated the statutory rights. It can be up to $75,000 per work.
Yeah.
But it depends. They have to meet some requirements for that. There are some criminal penalties, but that's pretty rare. And then again, so it really depends on the local laws. In terms of the future of copyright, you know, I think that we are going to continue to struggle with AI. I think we're going to struggle with the digital right to first sale, right? If I buy something online, can I transfer it to someone else? At this point in the US, at least, we don't have a digital right to first sale, but you know, that may be at some point we'll need to get there, because most things we can't even own because we license everything, right? Like streaming services and ebooks and things like that. So before I go, I wanted to thank the translator. I hope that I was going slowly enough that you were able to translate effectively, and I appreciate it.
He's feeling happy, I think. He sent me this reflection on you. So he's fine. Thank you.
Well, thank you everyone for having me. It was wonderful to meet with you. I know it's very late where you are, and I wish you happy holiday season. I know you're in the middle of your holiday season.
Thank you. Thank you so much, Sarah. And I always just learn from you and feel so excited about what you share with us. You will be a main person in shaping the future of copyright. So please share with us any update, and for sure we will be glad to host you again, to invite you to share your knowledge, and for sure your book. We received question about it, so we wrote it in the chat, and also it is in the ad for who they asking for more information about this. Thank you again. Thank you for all the attendees, and we would like to invite you for all the activity that Naseej Academy as a non-for-profit initiative trying to share the knowledge through it. Thank you again. Thank you to everybody. And the last word for thanking will come from you, Sara, for me and for the attendees. Please.
Thank you, everyone, and thank you for joining me. If you have other questions, you can always reach out over email. My email is srbenson@illinois.edu. Dr. Abdallah also has my email address. So if I really appreciate getting to speak with you. Thank you so much.
Thank you, and thank you for my colleague Saeed, and thank you for the translator, the very, very professional translator. We are happy to have him, Mr. Salah. And رمضان كريم عليكم جميعا إن شاء الله. نراكم إن شاء الله في ندوة أخرى. نترككم في رعاية الله.